Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implication into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation. Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator Dr. Varma Dayal Singh, who is out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula Mae Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula Mae Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Joss O.W. Drayton. Whereas Senator Dr. Varma Lennox Dayal Singh, HPM, is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula Mae Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Josh O.W. Drayton, to be a member of the Senate temporarily with effect from the 12th of November 2019 and continuing during the absence from Trinidad and Tobago of Senator Dr. Varma Lennox Dayal Singh, HPM. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President, St. Anne's, this 11th day of November 2019. Honorable Senators, a senator is required to take the oath.
I, Josh Drayton, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I'm about to enter.
Honorable Senators, in accordance with Standing Order 79-2, I wish to make the following appointments to the Sessional Select Committees for the 5th Session 2019-2020 of the 11th Parliament. Standing Orders Committee, Ms. Christine Kangaloo, Chairman, Mr. Nigel De Freitas, Member, Mr. Clarence Rambarat, Member, Mr. Wade Mark, Member, Ms. Sophia Choate, SC, Member. House Committee, Mr. Franklin Khan, Chairman, Mr. Foster Cummings, Member, Mr. Daniel Dookie, Member, Ms. Khadija Amin, Member, Dr. Varma Dialsingh, Member. Committee of Privileges, Ms. Christine Kangaloo, Chairman, Mr. Nigel De Freitas, Member, Mrs. Jennifer Batiste Primus, Member, Mr. Wade Mark, Member, Mr. Deerup Timal, Member. Statutory Instruments Committee, Ms. Christine Kangaloo, Chairman, Mr. Clarence Rambarat, Member, Mr. Rohan Sinanan, Member, Mr. Saddam Hosein, Member, Mrs. Hazel Thompson-Aye, Member. Business Committee, Ms. Christine Kangaloo, Chairman, Mr. Franklin Khan, Member, Mrs. Paula Gopi-Schoon, Member, Mr. Wade Mark, Member, Mr. Paul Richards, Member. Honorable Senators, I wish to briefly address you on the matter of Standing Order 103. Standing Order 103 states, the proceedings of and the evidence taken at a meeting of a select committee or subcommittee and any documents presented to and decisions of such a committee shall not be published by any member thereof or by any other person before the committee has presented its report to the House. I have noted with grave concern that in-camera deliberations and decisions of, as well as documents presented to parliamentary committees, have been making their way into the media long before these committees have the opportunity to report to the Senate. Most recently, the deliberations of the Joint Select Committee on Energy Affairs, held on Wednesday, October the 30th, 2019, were divulged to the media without the committee's consent and almost immediately after the committee met. Erskine May on Parliamentary Practice instructs, and it is recognized in virtually every legislature, that premature disclosures of the deliberations and decisions of a committee or of any documents which a committee has under consideration may be treated as a contempt. Honorable Senators, I wish to state at the outset that I view this matter very seriously, and I expect all members to do the same. The work of our parliamentary committees is very important and can only be successful if members can function knowing that their deliberations, which are conducted outside of the glare of the public, can be kept confidential until they choose to report to the Senate. This confidentiality provides committee members with the atmosphere necessary for free, open, and constructive analysis of the issues before them, particularly procedural issues. The unauthorized disclosure of committee evidence, documents, and decisions is unacceptable and will only serve to undermine and stymie the bipartisan work of our committees. Indeed, committee meetings, committee proceedings, reports, and all documents, including evidence which were not the subject of a public hearing of the committee, must remain confidential until tabled, and therefore to break this confidentiality is a breach of privilege. A Select Committee on Procedure of the United Kingdom House of Commons of 1989 to 90 said the following: all leaks are a breach of the trust among the members and staff of a committee, which is essential to its smooth functioning. If leaking becomes the common practice, then there can be a cumulative effect and a general slippage from the standards of responsibility in maintaining committee confidences that the rules require. This could damage the standing of select committees in the public eye. Experienced members are reminded, and similarly, less experienced members are advised, that during the 9th Parliament, a similar occurrence was deemed to be a contempt of the House of Representatives by a previous Committee of Privileges. There are also several other precedents, both here and in other Commonwealth parliaments, of the unauthorized release of committee work being treated as contempt. I therefore wish to condemn this breach of the standing orders and lack of respect for the privileges of the Senate, the undermining of confidence which will ensue due to unauthorized releases of the committees, in-camera deliberations, and confidential documents could be extensive and extremely counterproductive. I take this opportunity to caution all members of this Senate. It may be accidental or due to inadvertence, it may be the result of negligence, or it may be the deliberate release of information. The growing trend of disclosing, leaking, discussing, or sharing committee deliberations, decisions, and documents must be discontinued. This practice is wholly inconsistent with the dignity of this Senate, and as guardian of the privileges of this House, I will continue to ensure that there is no obstruction or interference placed on members in the exercise of their duties, whether collectively or individually. I so rule.
Bills brought from the House of Representatives on the supplemental order paper. The miscellaneous provisions, Law Enforcement Officers Bill 2019, in the name of the Minister of National Security. Petitions, papers.
Minister of Trade and Industry.
Madam President, I have the honor to lead the following papers listed on the order paper in my name. The Trinidad and Tobago Trade Policy 2019 to 2023. Thank you.
Minister of Labour and Small Enterprise Development.
Thank you very much, Madam President. Welcome back. We missed you. Madam President, I have the honor to lay the following papers listed on the other paper in my name. The administrative report of the Cipriani College of Labor and Cooperative Studies for the period 2015 to 2016. Thank you.
Minister in the Ministry of Finance.
Madam President, I have the honor to lay the following papers as listed on the order paper in the name of the Minister of Finance. The sector-wide approach program loan agreement between the Government of the Republic of Trinidad and Tobago and Corporación Andina de Fomento in the amount of $200 million. The report of the Auditor General of the Republic of Trinidad and Tobago on the statement of recovery of expenses of the Ministry of Energy and Energy Industries for the period ended December 31st, 2018. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Public Transport Service Corporation for the years ended September 30, 2015 and 2016. The reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the San Juan Laventil Regional Corporation for the years ended September 30, 2014 and 2015. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Tobago House of Assembly for the year ended September 30, 2009. The annual audited financial statements of the Petroleum Company of Trinidad and Tobago Limited for the year ended September 30, 2018. The audited financial statements of Caroni 1975 Limited for the financial year ended June 30, 2019, and the ministerial response of the Ministry of Finance to the 16th report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the Trinidad and Tobago National Petroleum Marketing Company Limited for the years ended September 31, 2008 to 2017. Thank you, Madam President.
Business.
Thank you very much, Madam President. Madam President, I have the honor to lead the following papers as listed on the order paper in the name of the Prime Minister, the Minister of National Security, the Minister of Housing and Urban Development, and in my own name. The ministerial response of the Office of the Prime Minister to the 12th report of the Joint Select Committee on Human Rights, Equality and Diversity on the sexual exploitation of children in Trinidad and Tobago, with specific focus on child prostitution and child pornography. The ministerial response of the Ministry of National Security to the 11th report of the Joint Select Committee on Human Rights, Equality and Diversity on the status of the implementation of the recommendation of the 3rd report of the Joint Select Committee on Human Rights, Equality and Diversity in the treatment of child offenders. The ministerial response of the Ministry of National Security to the 17th report of the Public Administration and Appropriations Committee on the examination into the expenditure and internal controls of the East Port of Spain Development Company. the Trinidad and Tobago Housing Development Corporation vesting amendment of the first schedule, number 2 order 2019, and the ministerial response of the Ministry of Energy and Energy Industries to the 16th report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the Trinidad and Tobago National Petroleum Marketing Company, Limited, NP, for the year ended March 31st, 2008 to 2017.
Reports from committees.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The report of the Joint Select Committee appointed to consider and report on the Private Security Industry Bill 2019 in the 5th Session, 11th Parliament. Thank you.
Minister of Labour and Small Enterprise Development.
Thank you very much, Madam President. Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The 13th report of the Joint Select Committee on Local Authorities, Service Commissions, and Statutory Authorities, including the Tobago House of Assembly, 5th Session, 2019-2020, 11th Parliament, on an inquiry into the efficiency and effectiveness of the National Emergency Ambulance Service. Thank you, Madam President.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Minister of Education, in light of reports of health and safety issues affecting the Edinburgh Government Primary School, can the Minister inform the Senate what immediate measures are being taken to rectify said issues?
Minister of Agriculture, Land and Fisheries.
Madam President, thank you very much. I thank the member for his question. And Madam President, in relation to immediate measures, a contractor is already on the site dealing with the issues. And in relation to the rectification being asked in the question, this will be completed by Thursday, 14th November 2019, which is 2 days away. And we thank the parents, the teachers, the students, the community for being patient as we deal with this particular issue. I thank you.
Senator Mark.
Madam President, through you, can I ask the Honourable Minister what is going to take place in the interim pending the completion of this exercise on the 14th of November?
Minister.
Madam President, the work that is going on now is targeted to the key area. This has to do with an issue of pigeon infestation and the risks that go with that. So the repairs are concentrated in the areas where the pigeons have found a home, that is in the ceiling. The repairs are being done to the existing pigeon proofing. There's a photo of the school on the newspaper today for those who are not familiar with Edinburgh, which is most of my friends on the other side. You would see the pigeon proofing on the photo, and there are repairs being done to that. In relation to some of the other aspects of health and safety, the washrooms need repairs and sinks and so on. This is not a new school, this is an older school, and there's cleaning and sanitization being done around the affected areas. So the staff is well aware, the parents, the students, and the Ministry of Education, Health and Agriculture have taken steps to ensure that the children and the staff are not affected during this short period of repairs, Madam President. However, some more significant work as a long-term solution will be done in the December vacation repair program, and that had already been programmed since during the August break for the December vacation period. Thank you.
Senator Amin.
Thank you very much, Madam President. This is a follow-up. I appreciate the information the Minister has given with regards to the medium and long-term solution. As of now, the children are in the school. I am asking what steps have been taken to ensure their protection and their health and well-being, given the hazards with regards to the pigeon infestation immediate from now on next till the repairs are over?
Minister.
Madam President, I must apologize for not making myself abundantly clear. The repairs are targeted to the affected area to the exclusion of the staff and students who have been advised, who are well aware, and who are not in the affected area. And the repairs are being conducted over the next, will be completed by Thursday, 14th November 2019. And between now and then, the staff and the students and the other persons entering and using the premises are not going to be affected because of measures the ministry has taken. Thank you.
Next question, Senator Mark.
Yeah, thank you, Madam President. To the Minister of Health, in light of claims by patients at Cora Hospital of a shortage of 4 critical drugs, can the Minister advise as to what measures are being taken to address this issue?
Minister of Health.
Thank you very much, Madam President. Madam President, there is no shortage of 4 critical drugs. And let me put on record, the 4 drugs are isoniazid, there are 114,200 doses. Ethambutol, there are 3,000 doses. Pyrazinamide, there are 3,300 doses. There is no shortage of these 3 drugs. There is a problem with a drug called rifampicin. And I put on record an article from the Globe and Mail of Canada, dated July 12, 2019. A looming shortage of a critical drug for the treatment and prevention of tuberculosis has physicians across Canada rationing pills. It goes on to say, Sanofi Canada, warning that manufacturing delays could prevent it from restocking rifampicin until next April, that is April 2020. There's a global shortage of rifampicin. What did we do as a responsible government? We sourced the clinical alternative called rivabutin. It's available. However, my understanding is not all patients are candidates for rivabutin. However, even in light of a global shortage, and anybody could type in global shortage rifampicin and it comes up. There's an absolute global shortage. Rifampicin is in the country and will be delivered to Cora Hospital today. So there is no shortage of tuberculosis drugs. There's a global problem with Sanofi of Canada in manufacturing the drugs, which they said will not resolve itself until April 2020. But we have circumvented that by doing 2 things, bringing in a clinical alternative, and we have supplies of rifampicin as of today. Thank you very much.
No. Next question, Senator Mark.
To the Minister of Health, given reports of the non-payment of outstanding monies owed to subcontractors involved in the construction of the Point Fortin Hospital, can the Minister advise as to what steps are being taken to address this issue?
Minister of Health.
Thank you very much again, Madam President. Madam President, the construction of the Point Fortin Hospital was predicated on it being a listed item on our MOU with the Austrians. This was never done by the UNC. It is this government that got it put onto the MOU. Because there was no MOU to start the project, there was no funding. And the UNC funded it from cash balances. It is this government, working with the Attorney General, working with Ministry of Foreign Affairs and the Ministry of Finance, that put the full funding in place via UniCredit of Austria for 81,395,922 euros. So it is this government that has fully funded the Point Fortin Hospital. So the hospital is fully funded because of the careful approach we have taken and not due to the recklessness of those who went before us in funding this from cash balances. As far as subcontractors are concerned, neither the Ministry of Health nor the government has any control over subcontractors. That's a matter for VARMED, who is the contractor, and UDICOT. But the project is fully funded, and my information is it will be finished for opening by March 2020. Thank you very much, Madam President.
Senator Mark.
Since the project has been fully funded according to the minister, can the minister share with this House, Madam President, the Senate, why these two P&M subcontractors have taken legal action against the government of Trinidad and Tobago through this agency to get monies that are outstanding, that are owed? Can the minister advise this honorable House as to the circumstances surrounding this development, Madam President?
Minister.
Madam Speaker, I have no control over the legal proceedings that may ensue, and there is something in this Honorable Senate via its standing orders called the sub judice rule. It will be reckless of me to even contemplate a comment. The Ministry of Health and the government has no locus standi when it comes to the hiring of these subcontractors. That is a matter for the main contractor, which is VARMED. However, as I said, lucidly clear, the project will be finished on March of 2020. And may I reiterate, if we did not fix this financing, do you know what legal challenges and what liability the state and the people of Trinidad and Tobago could have incurred because of the recklessness in not having this project on the MOU to build Point Fortin Hospital? The liability that could have flowed for breach of contract could have cost this country millions of dollars. Thank you very much.
Honourable Senators, the time has expired.
Questions on notice? Questions for oral answer?
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government will be answering questions numbers 1, 2, 3, and 45. We ask for a deferral of 2 weeks for questions number 46 and number 48.
Questions number 46 and 48 are deferred for 2 weeks. Senator Mark.
Question number 1 to the Minister of National Security.
Leader of Government Business.
Thank you very much, Madam President. Madam President, there are no immediate plans by government to construct a fire station in Cedros, although this can be considered in the future. While the concern of the Cedros residents are understood, the Chief Fire Officer has advised that the Point Fortin Fire Station, which has responsibility for responding to fire calls in Point Fortin and environs, inclusive of the Cedros community, has proven adequate in meeting the demands of residents. The government is proceeding with the construction of a new fire station in Point Fortin, which will have the necessary capacity to adequately serve the surrounding areas, such as in particular Cedros.
Senator Mark.
Can the minister indicate, Madam President, when this new fire station that is earmarked for construction will take place?
Minister.
It will take place in next year, 2020, most definitely.
Senator Mark.
Madam President, is the minister aware that the Point Fortin fire station is under-resourced and there's inadequate facilities to facilitate not only Point Fortin, but the wider community of Cedros? Is the minister aware of this situation affecting that part of the country?
Minister.
The government is aware that there are some challenges facing the Point Fortin fire station. It is currently housed in a ex-Petrotrin bungalow, and we are working assiduously to construct and rectify that situation.
Senator Mark.
Madam President, whilst the government has recognized that particular situation, can the minister indicate what immediate temporary measures can be taken to establish some interim solution in the Cedros community with the frequent occurrences of fires which have brought a lot of destruction to property in that community? What measures can be taken in the interim given the situation that exists currently in Point Fortin?
Minister.
Madam President, responding to fire calls for fire tenders. Once there are fire tenders at the Point Fortin fire station, they will respond and respond very, very quickly. It has nothing to do with the actual physical comfort of the building, although that is important also. But the response of the fire tender is what is significant in firefighting.
Madam President, the distance between Point Fortin and Cedros in terms of the fire services, equipment and resources, would the minister indicate whether the government is contemplating in the future to the establishment of some limited facility to service the residents of Cedros in the event of further, fires in that community, having regard to their past experiences?
Minister.
Senator Mark obviously didn't listen to me. The first sentence that I read from the answer is that there are no immediate plans by government to construct a fire station in Cedros, although this can be considered in the future.
Next question, Senator Mark.
Thank you, Madam President. Question number 2 to the Minister of Sport and Youth Affairs.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the Sport Company of Trinidad and Tobago is responsible for the construction, maintenance, and management of the country's major sporting facilities. In 2007, to serve the 100,000 residents of the Diego Martin region who were without a proper major sporting facilities, the then PNM government developed a plan for the construction of the Diego Martin Sporting Complex as a multi-purpose, multi-sport facility. The 2007 plan proposed a development in 2 phases. Phase 1, comprising a main pavilion with a seating capacity of 2,000 persons, internal side drainage, fence, main gate, field irrigation systems, field lighting, VIP lounge, media rooms, facilities for home and away teams, gym, and concession stands. Phase 2 is expected to comprise of a community play field, hard courts, children play park, car park, and training rooms. However, Madam President, the construction of this project was abandoned by the former government during the 2010 to 2015 period. The most densely populated part of Trinidad, the Diego Martin Valley, 100,000 residents with no sporting facility. It was abandoned by the UNC administration. After the 2015 election, construction work was restarted and the project was successfully completed and commissioned. This long overdue sporting complex was formally opened by the Honorable Prime Minister, Dr. Keith Rowley, in March 2019. In February 2019, Cabinet agreed that the government enter into a contract with UDCOT for the implementation of Phase 2. The sport company will provide a monitoring and oversight services for the project. 1. The tendering process for Phase 2 of the project will be in accordance with UDCOT's approved procurement policy and procedure, and the cost of Phase 2 of the project will be determined in due course.
Thank you very much, Madam President. Can the minister indicate, Madam President, in light of the fact that Phase 1 of that project has been completed, can the minister indicate the agency that is responsible for managing this particular multi-purpose sporting complex in the Diego Martin community? Can the minister advise, is it the sporting company or is it a special organization within the community? Can the minister advise, Madam President?
Senator Mark, that question does not arise.
The minister, can I go on, Madam?
Yes.
The minister has also advised that the tendering process will be conducted by UDCOT in accordance with its established procurement procedures. Can the Honorable Minister indicate when this second phase and the issuing of this tender for phase 2 will take place? Is there a time frame, Madam President, for this event to occur?
Minister.
Glad to see that the UNC is so interested in the Diego Martin sporting complex at this point in time. Phase 2 will begin and hopefully be constructed in 2020.
We're getting it done.
Next question, Senator Mark? No? Okay. Okay, next question, Senator Mark.
Thank you, Madam President. Question number 3 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, the government shall continue to be guided by the process of compulsory acquisition as set out in the Land Acquisition Act, Chapter 5801. This legislation regulates land acquisition and establish defined procedures for the acquisition of land and resettlement regarding affected persons in Trinidad and Tobago. The Act also has specific provisions to provide for fair compensation to those persons whose land is acquired by the state, bringing transparency to the entire process, and give the Commissioner of State Land the responsibility to acquire land on behalf of the state. When the state is desirous of acquiring land for public purpose, a Section 3 notice is published in the Gazette and at least one daily newspaper, no later than 7 days after the date of publication. The notice is required to be served personally or by registered post to the persons who is believed by the Commissioner to have an interest in the land. The Section 3 notice is a notice of intent to acquire. After publication of Section 3 notice, the Commissioner or his agent, in this case NIDCO, under the authority of the Ministry of Works and Transport, has the power to enter the land and conduct the necessary surveys to acquire as much data as possible on the properties. This would include, but is not limited to, social surveys, soil surveys, cadastral surveys, topographic surveys, site plan surveys, subdivision surveys. The publication of Section 4 notice gives the power to the state to apply the land to the purpose for which it is being acquired without waiting for formal vesting. By the time Section 4 notice are published, the Commissioner or his agent would already be in a position of information with respect to ownership of the land, and all preliminary surveys would have already been conducted. According to the Act, Section 4 notice will be published no earlier than 2 months after the date of publication of Section 3 notice. Madam President, the Tobago House of Assembly is also working on identifying various parcels of land to be made available to the residents who are affected by the land acquisition process. I thank you.
Senator Mark.
Thank you very much, Madam President. Madam President, can the Minister indicate how many persons in Tobago will be affected by this expansion of the A&R Robinson's International Airport.
Minister.
Madam President, the process, as I just outlined, is ongoing, and only when they process the Section 3 and the Section 4 notices would have been published to all the residents, then we will know exactly how many households will be affected. And that is why this process is free and it is fair to everyone, and it allows the government to go in and identify exactly the land that is required. I thank you.
Senator Mark.
Madam President, through you, can the minister indicate whether the government, through NITCO, National Infrastructure Company, has determined the actual size of the area earmarked for the expansion of the A&R International Airport?
Minister.
Madam President, this project have been long in the making, and the area earmark have been identified. However, until all the surveys and the process is completed, only then we will have an exact amount of properties that is required. Thank you.
Senator Mark.
Is the minister aware that there is massive dissatisfaction among the potential residents that are to be relocated from their homes, which they have been occupying for decades, if not centuries? Can you indicate to this honorable House?
Well, you just asked a question.
Yes,
Is
Madam
the minister
President.
aware?
Yeah. Is the minister aware that there is growing discomfort among the residents whose properties are earmarked for relocation?
Minister.
Madam President, it is never easy when someone has to part with a home, especially when you would have had family going back, and so it is never easy to take that decision. However, any government must act in the best interest of the national population. And this is why the government would have chosen this process. What the government has to ensure is that we continue to develop the country as a whole for future generations. We must ensure that taxpayers are not saddled with a bill that is totally ridiculous, as what happened in the San Fernando to Point Fortin Highway. And we must also ensure that the families who are going to be relocated do not suffer any social impact. The government will take all these responsibility on board, and we would have learned significantly from the way the acquisition was done in the San Fernando to Point Fortin Highway, and this government will never make that mistake again. We will stand up and we will do what is right to ensure that everybody who might be affected will be treated fair in terms of their compensation package. Thank you.
Senator Mark.
Madam President, can the minister indicate whether this project has been hijacked by NITCO at the expense of the Tobago House of Assembly that has responsibility for such a project in Tobago? Can the minister indicate whether the Tobago House of Assembly role has been undermined by central government through NITCO invasion of Tobago, giving the people of Tobago a raw deal in the process? Can you clarify that for us?
So, Senator Mark, that question does not arise. Next question, Senator Obika.
Thank you, Madam President. Question number 45 to the Minister of Education.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the answer to Roman 1. For the academic year 2018-2019 and the current academic term, no other allegation of discrimination against students wearing a natural hairstyle has been reported. There were 3 cases, however, reported where the issue identified was one of grooming and hygiene for the same period. The matters were resolved amicably at the school level and with the parents and school supervisors. Response to Roman 2. The school supervisor, on receipt of the complaint, met with the school administration, which are the principal, the vice principal and dean, and the archdeacon of the Anglican Church. Discussion centered on 1, Section 7 of the Education Act, Chapter 3901, which treats with the prohibition of discrimination, and 2, the revised National School Code of Conduct, May 2018, Principles of Respect and Rights. Further, the principal gave the assurance that no student at that school will be denied an opportunity for education because of any form of discrimination. The student in question continues to wear her natural hairstyle without any negative repercussions, and so do all other students.
Senator Vieira.
Thank you, Madam President. Because this question of hairstyles prohibition is a relic of a colonial era. And I want to ask the question, please. I want to ask the question, what redress mechanisms that are officially available, apart from that special circumstance, that are officially available to school administrators, be it principals, teachers, and as well parents?
No, that question doesn't arise based on the response given to the question that has been filed. The next question, please, Senator Vieira.
Madam President, I'm confused because to me there was no mechanism mentioned there.
Senator Vieira, yeah, move on. Ask another question. I have ruled.
Okay. The question is, what is the role then of the NPTA? Was the NPTA invited to that meeting?
Minister.
So, Madam President, the school as an administration, the school supervisors met with the principal, the vice principal, the dean, and the archdeacon of the Anglican Church, because it is a denominational school. The discussion centered on Section 7 of the Education Act, prohibition of discrimination. On 2, the revised National School Code of Conduct. And the situation was amicably sorted out. And if people can take lessons from these, the chances of such a situation reoccurring should be very small. And let us progress as a society. We know it was a historical relic and a colonial relic, but we are moving on. And this society, despite all the detractors, is getting better and better in matters pertaining to issues like these.
Senator Vieira.
Madam President, I just want to say that I got calls from as far as the Emancipation Support Committee on this issue. Many people reached out to me on this issue.
Vieira, please.
And the question is, why was the National Parent and Teacher Association not involved? The Parents Association is important. The parents went by themselves, so you stack the meeting against the parents.
Senator Vieira, please take your seat. You have an opportunity to ask questions. You've been in the chamber long enough to understand how to frame your questions. Okay? So that question will not be allowed. Senator Amin.
Follow up to this question, Madam President.
To one that has been allowed? To a question? Yes. Continue.
Madam President, through you to the Minister. Excuse. Given the lessons out of this and given the acknowledgement by the Minister that the rules may be a bit old, is there any move on the part of the Ministry or the government to revise the rules and guidelines with regards to matters like these?
Now, I think maybe I was the only person listening to the answer that was given. Minister, I will allow you to answer that question.
Madam President, the rules are there. Section 7 of the Education Act deals with prohibition of discrimination. The revised National School Code of Conduct speaks about principles of respect and rights. These are, the Education Act is what governs the education system in Trinidad and Tobago. If situations like these arise so infrequently, and when they do arise, it is sorted out amicably, we have to say that we're in a good space. And I personally am proud to see how the Anglican board responded to this in a way, and the answer is clear that the matter has been amicably resolved.
Introduction of bills. On the supplemental order paper, the Copyright Amendment Bill 2019 in the name of the Attorney General. Motions relating to the business or sittings of the Senate and moved by a minister.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I beg to move the following motion. Be it resolved that the Senate agree to the appointment of Mr. Foster Cummins to the Public Accounts Enterprises Committee.
Honorable members, the question is that the Senate agree to the appointment of Mr. Foster Cummings to the Public Accounts Enterprises Committee. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Public business, government business, bills, second reading.
Attorney General.
Thank you. Thank you, Madam President. Madam President, I beg to move that an act to amend the Bail Act, Chapter 460, be now read a second time. Madam President, the bill before us today is a 3/5 majority bill requiring the support of more than the government bench. It is a bill which is a mere 3 clauses long, but despite the brevity of the bill, it is indeed a very deeply important piece of bill, of law, of proposed legislation for consideration by this august House. Madam Speaker, Madam President, Trinidad and Tobago is at war. The issues of the crime situation, the issue of the economy, are 2 central issues that have not been center stage only in the last 5 years or in the last 10 years, but indeed have been anchored in the fulminations of many of our writers, many of our commentators, and certainly in the hearts of citizens for a very long time. I recently came across the 1973 writings of the committee set up to look at the reform of our independence constitution, and that committee's work then resonated in the 1976 constitution. And center stage in that particular reflection came the submission of the writers that Trinidad and Tobago was in a fight for its life, where there was a growing criminality, where there were young people up in arms, unemployed, where they were seeing at that point in time a rise in crime which seemed to have no dissipation and no relief. The statistics in the criminal justice system, in the court system, all demonstrate that criminality has grown as a direct ratio measured against the growth in our society. There was a point in time when our society was a mere 300,000 people. We are now a 1.3 million, close to 1.4 million population. And Trinidad and Tobago right now wrestles, as many of our parliaments have, certainly in relation to amendments to the Bail Act, we wrestle with finding a proportionate balance between the protection of the rights of the individual on the one hand and the society as a whole. Our constitution is quite unique, Madam President. It is in fact a constitution which stands unique in the CARICOM context and very much so in the Commonwealth. Our Constitution, in its preamble, in its anchoring of enshrined rights in sections 4 and 5, our Constitution recognizes that we may abrogate or derogate from enshrined rights in section 4, in section 5. One of the rights standing out obviously in section 5 is the right not to be deprived of bail without reasonable cause, if you put it quite simply. Our Constitution recognizes in sections 13 and section 54 that a parliament properly assembled can, with sufficient majority support, in this case 3/5 majority support, abrogate or derogate from what are set out as enshrined rights. Now, Madam Speaker, Madam President, it's true that we are looking squarely at the following rights: the right to liberty and the right not to be deprived thereof except by due process of law, the right to protection of the law, the right not to be subject to arbitrary detention and imprisonment, the right not to be deprived of the right of fair hearing in accordance with the principles of fundamental justice for determination of rights and obligations, and the right not to be deprived of the right to reasonable bail without just cause. Those are the essence rights contained in sections 4 and 5 of the Constitution. But we are also treating with a very important core constitutional concept, and that is the separation of powers principle. The separation of powers principle quite simply says that the three pole architectural points of management of our society, that is the judiciary, the legislature, and the executive, ought not to so intrude upon each other's purpose as to offend the separation of powers which they ought to have, because that is how the balance happens. The courts interpret the law, the executive provides the purpose, the parliament considers law in the round. And I would like to say that I am entirely satisfied that the amendments that we propose today are permitted in the context of the constitutional arrangement, that is section 13 of the Constitution, which has two limbs. Number one, if it is to be passed by 3/5 majority support, and number two, that it is reasonably justifiable in a society such as Trinidad and Tobago. And secondly, and very importantly, and I say this up front because I had the chance to have a very brief conversation with a couple of the senators before the start of this, I'm going to address squarely the issue of separation of powers and perhaps the misunderstanding that this bill seeks to intrude upon the separation of powers. And I say misunderstanding because the bill as it is crafted in the explanatory note, I think the explanatory note can take one along the wrong path, because even though the explanatory note does not form part of the law, Clause 3 is set out in the explanatory note as saying, Clause 3 of the bill would provide for the inclusion of the offenses of possession of firearm or possession of weapon for the purpose of trafficking under Section 9A of the Firearms Act, Chapter 1601, and possession of a prohibited weapon as offenses for which person would be denied access to bail for the period of 120 days under the Bail Act, Chapter 460. It does not go on to provide for Section 7A of the Bail Act, which was in fact brought into law when we as a parliament last sat together and came up with Act number 17 of 2019. That is where we amended the Bail Act, and that was assented to on the 5th of August 2019. So those are the two constitutional purposes that I propose to speak to in underpinning the proportionality of this legislation and therefore its propriety for consideration. I'm obliged to put now the factual matrix of Trinidad and Tobago, so that in the event that there is a challenge to this law, which can only be a challenge to constitutionality of the law, that the factual matrix of Trinidad and Tobago as it stands is on the record via the mover of the bill under the consideration principles of the rule in Pepper and Hart. That said, quite simply, what we are talking about, what does Trinidad and Tobago look like? What are our statistics? What are we grappling with? How does that fall into the concept of Section 13(2) of the Constitution, where we are looking at what the reasonableness of the legislation is in a society such as Trinidad and Tobago, not any other society that respects the rules and principles of democracy. Madam President, therefore, I now put onto the record the following. Let's go very quickly to the statistical arrangement in Trinidad and Tobago. It is now a matter of course that this Parliament, this Senate in particular, is well seasoned in statistical information. I can tell you, Madam President, that in the 5 years that I served in opposition, we did not have the presentation of statistics to anchor legislation which we were considering, certainly as it relates to the bail amendments that were considered in Act number 9 of 2011, Act number 11 of 2011, Act number 12 of 2012, Act number 1 of 2014, and Act number 7 of 2015. We had no grounding of statistical information. The 3/5 majority amendments brought into there, which was to deny flatly the right to bail being considered by a court. Let me repeat that. The 1, 2, 3, 4, 5 amendments which came from the now opposition, then government, in the period 2011 to 2015, which was passed by 3/5 majority, they denied the court the access to considering the grant to bail, specifically as it related to Schedule 2 offenses, which included anti-gang legislation, anti-kidnapping legislation, trafficking in persons legislation, etc. Those pieces of law, which were a carry-on from the 2006 amendments come forward, those pieces of law flatly denied the jurisdiction of the court. It is necessary, therefore, Madam President, to remind, today we are in fact on the 17th amendment to the Bail Act. Quickly, in 1994, Keith Sobian, then Attorney General, approached the Parliament, codified the bail legislation, because the common law was what treated with bail. In the period 1994 to 2005, the Act stood as it was. Effectively, there was a 3 strikes principle. You would be denied bail if you came forward for 2 matters. One, the Part A schedule, which dealt with, of course, murder and the other capital offenses, treason, etc., where we kept the save law and said that there will be no bail pursuant to our pre-1962 law. But on the second occasion, the 3 strikes rule came in 1994, and there was a codification of the common law. In 1994, the law actually provided for the judiciary to have a discretion in the Bail Act. It was in 2005, straight up to 2008, that Trinidad and Tobago was fighting the scourge of kidnapping for ransom. And in 2005 to 2008, there were multiple iterations of the bail law, and the law was introduced and passed with 3/5 majority support to say in kidnapping for ransom matters and certain other serious matters, there would be an ouster of the court's jurisdiction to consider bail in certain circumstances, where if your matter started within 120 days, you would be denied bail. You would have a second aspect if your matter was not completed at the end of the year, and in that year, you were effectively denied asking a court to grant you bail. That was passed on each occasion with 3/5 majority support. In many instances, there was a lot of fight, because when the UNC is in opposition, they say no to what they promote as law, and therefore there were sunset clauses, some as short as 3 months. It was in 2011, by Act number 9 of 2011, that we started changing the no bail considerations from 60 days to 120 days no bail. That was again supported in the introduction of the amendments to the anti-kidnapping and bail considerations. In Act number 11 of 2011, we introduced gang legislation, anti-gang legislation, and again there was an ouster to the court considering. That went straight up to Act number 7 of 2015. And effectively in that period, 1994 to 2015, what we saw in 2005 was the introduction of the right to appeal for prosecution and for the defense. We then saw the ouster of the court in the circumstances of kidnapping for ransom, etc. We saw the move away from 3 strikes to 2 strikes to 1 strike in 2015. And that law stood perfectly on the books of Trinidad and Tobago with a very important result. Kidnapping for ransom by the year 2009 went effectively out of existence. Now let me put on record, there has not yet been at the Privy Council, which is the highest court of appeal for Trinidad and Tobago, a case which considers the 3/5 majority legislation of this type. The first of those cases will be coming to the Privy Council, and that, Madam President, is to be found in the cases of St. Omer and Charles. In the cases of Daniel St. Omer versus the Attorney General, it started as CV 2015-03475, and Justin Stuart Charles versus the Attorney General, which started as CV 2016-00074. In those cases, quite interestingly, the latter one in particular, Anand Ramlogan, Gerald Ramdeen, as members of the UNC, Ramlogan standing as Attorney General of Trinidad and Tobago, who saw the birth of Act number 9 of 2011, Act number 11 of 2011, Act number 12 of 2012, Act number 1 of 2014, and then the UNC taking paternity or maternity of Act number 7 of 2015. All of those acts which ousted the court's jurisdiction with UNC piloting and support, Mr. Ramlogan arrives now to challenge the constitutionality of the exclusion of the court's jurisdiction. Let me repeat that. Pass the law whilst you're in government, get fired, go into the public domain, and then take a case to challenge the constitutionality of the very law which the UNC piloted on 5 occasions, Madam Speaker, Madam President. Madam President, in those circumstances, the statistical information standing in Trinidad and Tobago's docket as it is right now demonstrates, and I'll go to the targeting of this bill. In this bill, we propose that we amend Section 5 of the Bail Act, as recently amended by Act number 17 of 2019. We propose that we amend that particular law to include in the no bail consideration subject to Section 7A, we propose that we include, if you come before a court and Section 5 of the Bail Act is read, that subject to Section 7A effectively, a person who on or after the commencement of the act is charged with an offense as amended of being charged for trafficking in firearms pursuant to Section 9A of the Firearms Act, or being in possession of prohibited weapons of military grade, those persons will fall into the bucket of persons who a court ought not to consider granting bail, subject entirely, Madam President, to the provisions of Section 7A of the Bail Act, as amended by Act number 17 of 2019. And Section 7A says this, Madam Speaker, Madam President. Notwithstanding subsection 3 and subsection 7, and subsection 3 says it is those provisions where you will be now amending and adding in trafficking in firearms and also possession of military-grade artillery. Notwithstanding subsections 3 and 7, a person to whom those subsections apply may, in exceptional circumstances, make an application to the court for bail. You can only figure this out if you read the Act as a whole. The inclusion of Section 7A is pellucidly clear. It applies as an exception to the law that we are now proposing in this bill. So statistically, what are we treating with? Madam President, may I ask what time I end in full time?
1137.
Thank you, Madam President. Madam President, let's go to persons charged for the period 2009 to 2019. And let's go to that period ending 30th of June 2019. I can say this, Madam President, for firearm types going across the range: revolver, pistol, shotgun, homemade shotgun, rifle, trap gun, flare gun, machine gun, submachine gun, other air rifles. In total, we have had, in that 10-year period, 6,588 persons. I'll go specifically to the subsets machine gun and submachine gun. For machine guns, there have been 97 people charged. For submachine guns, 44 people. Machine guns and submachine guns. Madam President, what I can tell you is that the reports of firearm-related offenses, 2009 to 2019, we have had in that 10-year period firearm offenses being reported, 17,908. Arrests for possession of firearms. In 2009 to 2019, we've had 5,900 persons. Arrests under the Anti-Gang Act, 2009 to 2019, not including the several alleged gang leaders that have recently been arrested, we had 213. Madam President, what we can say, we have had arrests also in the Anti-Terrorism Act, under the Anti-Terrorism Act, and under the Trafficking in Persons Act, and under the Kidnapping Act, 2009 to 2019, we've had 876 arrests. Madam President, what I can say, serious crime detection rate 2009 to 2019 demonstrates detection rates across that 10-year period as follows: 17%, 16%, 19%, 17%, 18%, 23%, 23%, 24%, 31% at 2017, 34% at 2018, 30% at 2019, which is still going on. Detections, 34,080 for that 10-year period, reported 156,630. In other words, even though in the last 4 years the detection rate has gone up, we are looking at 30%. We therefore fall to the philosophies and theories of law. Can law stand as a deterrent? Can law modify your society's behavior? Do we have examples of that? Yes, indeed we do. Look at the seatbelt law. Look at the introduction of speed guns via legislation in causing Trinidad and Tobago to slow down. In this particular direct effect of the considerations of the bail amendments, look at the effect in the drop to near zero of kidnapping for ransom. From a scourge in 2005 to 2009, the phenomenon dropping to nearly zero. Why? Largely due to the credit of the restrictions on bail. Now, Madam President, let me put this into the mix now. Trinidad and Tobago is not being asked today to carry on the law that stood on the books of Trinidad and Tobago up to 2016 when the bail amendments fell flat. You will recall, even though the UNC piloted bail amendments 5 times in the period 2011 to 2015, they came to this Parliament and they refused to extend the sunset period for 2 years to allow the bail amendments as they stood to go into effect. That caused the bail law to collapse back to the 1994 law, 3 strikes, as slightly amended by the 2005 amendments, which still stood for the right to appeal, etc. And effectively, that law changed only by Act number 17 of 2019. That law changed with this Parliament, this Senate supporting the bail amendments. And what did we do in that law, which was assented to on the 5th of August 2019? We introduced something which is a constitutional measure never before applied in this jurisdiction in that way. Specifically, we introduced in those amendments, and the Senate will recall, and it's germane today to the debate, we introduced, if you have a charge and a conviction for scheduled offenses, you will not be considered for the grant of bail, subject to Section 7E. If you have a charge for possession of firearms and you come for another charge for possession of firearms, you will have no consideration of bail, subject to Section 7E. If you have a charge for if you have a charge in the scheduled offenses and you come before, again, treating with a firearms offense where you're using it in the course of the conduct of an offense, again, you'll be considered for no bail. But very importantly, you will hear me constantly repeating that this law was subject to this Senate agreeing to the introduction of Section 7A of the Bail Amendment Act. And Section 7A, Madam Speaker, Madam President, is the section that I referred you to a little bit earlier, where we added in the following language, and I'll repeat it at this point. Section 7A, notwithstanding subsection 3, and subsection 3, which is 5.3 of the Act. 5.3 is where you say no bail in certain circumstances, notwithstanding Section 5.3, notwithstanding Section 5.7. Section 5.7 is where you're dealing with the anti-gang provisions, where you're dealing with a child or somebody who's in loco parentis. Notwithstanding those sections, a person to whom those subsections apply may, in exceptional circumstances, make an application to the court for bail. We specifically said that the court included the range of judicial officers, the magistrate, the judge, the master. We specifically put that into the law. And why did we do that, Madam President? We did that because we accepted, number one, that there ought not to be a breach of the separation of powers. Number two, this government proposed specifically that we ought to maintain the sanctity of Section 5.2F3, Roman 3 of the Constitution. It is Section 5.2F, Roman 3 of the Constitution that says you ought not to deny bail without just cause. We also saw it as fit to address the Section 13.2 of the Constitution issues, a society such as Trinidad and Tobago fighting the scourge of crime, having submachine guns, having machine guns, having thousands of reported matters, having murder statistics close to 500 right now. Remember, a murder is mostly, insofar as firearms are used, a shooting gone right from the killer's perspective. The wounding and aggravation by firearms is where the murder goes wrong. So if you add those two together, we're fighting a scourge. In recognizing no breach of separation of powers, preservation of Section 5.2F, Roman 3 of the Constitution, Section 13.2 considerations of the Constitution in terms of proportionality, as they are well anchored in the cases that we're now very well familiar with, whether they originate from the European Court, whether they originate from the Privy Council or from the local jurisdictions, we said introduce Section 7A to Section 5 of the Act. And that is to preserve the court's jurisdiction. Madam Speaker, Madam President, of course, persons can stand today, refer us to Caballero versus the UK appeal, that's the European Court. They can refer us to SBC versus UK. Of course, the very famous case of State of Mauritius and Coriati, R.V. Morales, R.V. Pearson, all of the cases, Northern Construction, whatever they may be, we'll be looking at the position of proportionality. Is there a legitimate aim? Is the aim rationally connected with the purpose of the bill? Do we go any further than we must in derogating from certain enshrined rights? And is it proportional and proportionate in a society such as ours? Senator Thompson, you wanted to ask something?
Yes. Through you, Madam President, I hate to stop the Attorney General, the Honorable Attorney General, in full flight, but he keeps alluding to Section 7. And when he really means subsection 7. Yeah. And you see, then it has to go into the Hansard. Anybody reading it? So thank you. I have been going back and forth. And I know that 7 is the sunset clause, so you couldn't mean that.
Thank
so
you,
if
Senator.
you could say subsection when it is subsection.
Section 5, subsection 7A
Thank you very
of the Bail Act. Of course, I'm speaking quite quickly, mindful of the fact that I have 10 minutes left to do justice to this legislation, and I thank the Honourable Senator for getting the Hansard right. So, Madam President, this has direct precedent. This has direct precedent in a law coming out of England, Criminal Justice and Public Order Act 1994, in the introduction of Section 25 to that law, as it was amended after the European Court effectively said to the UK government, you cannot oust the jurisdiction of the court. That's the origin of Section 5, subsection 7A, which we as a Senate put into law, and which stands as the measure against any argument against constitutionality for the inclusion of trafficking in weapons, introduced in the Firearms Act by Act number 18 of 2019, assented to on the 19th of September 2019. We just amended the Firearms Act to include for the first time the concept of trafficking in firearms and ammunition. And we said if you have 2 or more firearms that you would be trafficking. And we introduced into that law where you are in possession of military weapons. We took the definition of prohibited weapons. Prohibited weapons is defined in the Firearms Act, but we narrowed the definition of prohibited weapons down to what we are considering to be offensive to our society. And the prohibited weapons effectively stand as follows, and it is set out in this Bail Act. Prohibited weapon means artillery or automatic firearm, grenade, bomb, or other like missile. So we are narrowing the definition of prohibited weapons because in the Bail Act, it is to be narrowed, but in the Firearms Act, it is a broader definition. In the general interpretation section, the clause 2 of that legislation, section 2, and also in the possession aspects where we introduce trafficking in firearms, the new section 9A of the Firearms Act in particular. But in the UK, and I think it's germane to this debate, it is in fact the parliamentary speech coming from Lord Falconer that really addresses why we are in part treating with this. In the piloting of the amendments to Section 25 of the United Kingdom Criminal Justice Public Order Act, it was Lord Falconer who moved that particular position, who really set it right, I think, Madam President. And I want to put it onto the record here, and I quote. This is from the House of Lords speech. We consider that in the exceptional cases at which Section 25 is targeted, and we have exceptional cases, it is right to reverse the general presumption in favor of bail, because that is what we do, and shift the onus onto the defense to provide good and sufficient reason why bail should not be denied. We do envisage that this new burden on the defense will be easily overcome in most cases, but to rule out the possibility of granting bail cannot be justified. We see this new provision as allowing some flexibility to prevent injustice while ensuring that the protection of the public remains the primary concern and providing a tough additional safeguard against bad bail decisions in these particularly serious circumstances. I saw a small smile from Senator Choate, who I respect in the most sincere way. Yes, do we have bad bail decisions? We do. Yes, did we in 2005 introduce the concept of appeal, both for the defense and for the prosecution? Yes, we have. Yes, we can, as a parliament, decide to say what the parliament says ought to be considered. We, the elected and appointed representatives of the people of the Republic of Trinidad and Tobago, have a unique voice and privilege under the Constitution, in the Constitution allowing us to make under Section 53 of the Constitution laws for the good order of Trinidad and Tobago, peace, order, and good governance. Do we have a problem with firearms in this country? Yes, we do. Are we detecting them? Yes, we are. Are we catching all of them? No, we are not. Paucity of evidence, witnesses not turning up. That is the matter of the evidence considerations which are in Joint Select Committee, which there is a prohibition against discussing at present, but we're trying to treat with evidence. Yes, are we asking the police to go out and do more drilling? Yes, we are. But when we have reported incidents, as are littered in the newspapers, of mothers being gunned down with automatic firearms, children being shot dead in scattered gunfire with automatic firearms, up to 19 automatic firearms being found in one location, we have the privilege and ability to cause amendments to the law. Are we saying to the court that you have no role in this purpose? No, we are not. Are we asking for the defense to be in a position of a reversal of burden of proof? Yes, we are. Can we do that under the Constitution of the Republic of Trinidad and Tobago? Yes, we can. It is set out in Section 5 of the Constitution. The reversal of burden is a particularly unique circumstance. The burden shifts once the defendant has done certain steps, and the prosecution must then go on a proof beyond reasonable doubt to deal with the rest. But, Madam President, where we are treating with a prohibition against firearms, as we agreed as a Senate that we ought to, we, the Senate, I, the guest in the Senate, the mover of the bill, we passed the trafficking in firearms clause. We passed the possession of military weapons in the prohibition of the prohibited weapons circumstances we did. Today we are saying, and hence my position that it is deceivingly simple, today we are saying in Section 5, subsection 3 of the Bail Act, we are asking, pursuant to Clause 3 of this bill, we are saying, let us consider the introduction of reversing that burden of proof, having the defendant show just cause in exceptional circumstances why bail should not be granted. Let the court take an extra step and consideration as to those matters. And I can tell you this, Madam President, in the case of R.O. versus the Crown Court at Harrow, Lord Brown in that particular case, UK House of Lords 42, 2007, one appeal cases 249, dealt with the Lord Falconer approach, dealt with the prohibitions and the reversal of burden, and effectively said that there was no real placing of an evidential burden to the point that offended justice. So there's been, since 2005, 2006 in particular, there has been fulsome consideration of the precedented version of what we are doing in similar circumstances to Section 25 of the Criminal Justice and Public Order Act 1994 as it has been amended in the United Kingdom. Canada has a similar approach and run up to the wicket, and they also have that position clear. But Madam President, this management of crime and criminality in Trinidad and Tobago cannot be without reference to the Parliament. It is for us to decide what we consider to be offensive or non-offensive. Section 3, we're asking for a simple possession point. If you are brought before the court where you are in possession of prohibited weapons, meaning artillery, automatic firearm, grenade, bomb, or like missile, the court ought to consider not granting you bail, but you can, pursuant to Section 5(7)(a) of the Bail Act, in exceptional circumstances, say to the court, listen, I want to hear my access to bail. You have the right of appeal. You have the defense and prosecution having that, and we are saying, in those circumstances, these things are so odious, trafficking in firearms. These things are so odious, grenades, missiles, automatic firearms, that our Parliament ought to have people on the first occasion of coming before a court explain themselves to the court. Why would you want to be in possession, as has been reported in the newspapers, of 19 automatic firearms? What reason could there be? This is not anecdotal. This is now a matter of fact in our jurisdiction. I make no aspersions as to guilt or innocence, but I'm drawing an example that the country is well aware of. It is an opportunity for us to consider righting the ship. Have we done it before? Yes. We did it in the amendments between 2006 to 2009, where we dealt with the kidnapping for ransom scourge. There was a benefit. Are we seeing a push by our law enforcement? Yes, we are. Madam President, I'm confident that honorable members will have a fair amount to say today. I welcome the submissions to come from the respective benches. I ask us to think very carefully about the coordination of laws that we are engaged in, and I look forward to having a proper response, reply, perhaps amendment to any considerations that honorable senators may have. I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Senator Hosein.
Thank you. Thank you very much, Madam President, for allowing me the opportunity to contribute to this act to amend the Bail Act, Chapter 460. And Madam President, we would have missed you for the period that you would have not been here, but the last time I expressed such sentiments, I was ejected, so. But Madam President, we are engaged in a very serious discussion today that deals with the restrictions of certain constitutional rights and privileges of individuals and citizens of Trinidad and Tobago. And in particular, the right to bail when one is charged under the criminal law. And Madam President, it was like deja vu, because I could remember, I believe it was in June of this year, that this Parliament would have considered and deliberated on the Bail Amendment Act, Act 17 of 2019. And that debate took place in June and July of this year, and the bill was assented to on the 15th of August 2019, where there were a host of various restrictions being placed on the right to bail. And Madam President, the bill before us is one that amends those provisions of the last act, which is Act 17 of 2019, by creating two categories in which bail will be denied. And those are for persons who are charged with trafficking of firearms or who are charged with the possession of a prohibited weapon. And Madam President, when a Parliament, through the policy of the government, seeks to restrict one's constitutional rights, there must be a high level of accountability, because you are denying effectively a person his constitutional right to bail and also his right to liberty. So therefore, once these heavy restrictions are put in place and imposed, it is on the account of the government to come to the Parliament to justify further restrictions. So I would have thought that the Attorney General, while piloting this bill, would have given us a report, Madam President, of what has taken place with respect to the effectiveness of the last amendment that we would have passed in this Parliament. So that we would have had an idea, Madam President, of how many persons would have been captured by this new Act 17 of 2019 here, because now we are going to create further restrictions to the right to bail. So as a Parliament, and for us to make a more informed decision, you should have explained to this House and the country what is the effectiveness of the previous law. How many persons were charged and denied bail under that particular law? How many persons' trials have been started? Whether any of those cases, if any, there have been charges, what stage of the proceedings those matters are at. Because this bill runs for, there's a sunset clause in this bill for 2 years in the last act. So you're creating this restriction for a very long period of time. And if you would allow me, Madam President, I'd just like to go through some of the categories in which a person would have been denied bail under Act 17 of 2019. If you're charged with a scheduled offense, but you have a conviction for an offense that carries imprisonment for more than 10 years, you're denied bail. If you're charged with possession of firearms and also has a pending charge for possession, you are denied bail. If you are charged with a scheduled offense and has a pending charge for a scheduled offense, you're also denied bail. And if you have a charge for a scheduled offense, but the prosecutor informs the magistrate that you used a firearm in the commission of that offense, you're also denied bail. Now, the categories in which we are going to include here is charged for, when you look at clause, the bill is very short. When you look at clause 3, subsection D of the bill, is that you're going to deny bail for a person who has a charge, first offense, no pending offense. So once you have a first offense charge for trafficking of firearms under Section 9A of the Firearms Act, you are denied bail for a period of 120 days. Secondly, if you have a first charge for possession of a prohibited weapon, which is defined as artillery or automatic firearm, grenade, bomb, or other like missile, you are also denied bail for a period of 120 days. Now, Madam President, I admit that it is a problem. No right-thinking citizen of this country should have in his possession any automatic firearm or any automatic rifle, a bomb, a grenade. No one should have that. But, Madam President, what is important is that the citizens of Trinidad and Tobago must have their constitutional rights. Those rights should not be arbitrarily be taken away from them. Because what is the ultimate test for bail? Bail is not a punishment, Madam President. Bail is not meant to be something to punish an accused. Bail is meant to secure an accused attendance at trial. That is what bail is. The Bail Act goes through several factors in which the magistrate, which the judge, which the court of appeal will take into account when a person is effectively granted bail, when they are denied bail, or when their bail is varied. So, Madam President, what this bill does, it was a reactive measure. Because in this country, you have an Attorney General, you have a Minister of National Security, and you have a Commissioner of Police. The Minister of National Security is responsible for setting the policy of the government. The Attorney General is responsible for converting that policy into law and bringing it to the Parliament. And thirdly, the Commissioner of Police is charged with the responsibility to enforce the laws that this particular Parliament passes. That is how I understand the system to work. Now, Madam President, the Commissioner of Police expressed severe dissatisfaction with respect to an instance that took place in the courts with respect to the granting of bail. And all of a sudden, there was an amendment to the Bail Act. So it seems in this country that the Commissioner of Police have to fight crime, he have to tell the government which law he wants, and he have to create policy. That shows the incompetence of this PNN government. Because without Gary Griffith, the Commissioner of Police, this government is blindsided when it comes to crime. They have no idea what to do with respect to fighting crime in this country, Madam President. They have nothing to add. And you would have thought that we would have just amended this bill, this act. This piecemeal approach that this government keeps coming to this Parliament with, Madam President, is that the prevalence of firearms and submachine guns and machine guns is nothing new. Because when we debated this bill earlier on, the Attorney General provided us with the statistics. And on the statistics, you have machine guns and submachine guns. Why you didn't include this amendment in the previous bill? We are just wasting more and more precious and limited Parliament time, Madam President, with the piecemeal approach that this government is taking. The opposition has always called for a holistic approach and a holistic view with respect to the criminal justice system in this country, Madam President. That is what we are about. Don't come one day, today you want to amend the Bail Act in Section 5, and then you want to come back and re-amend that section and do the same thing over and over and over, Madam President. We are wasting parliamentary time. Do the work properly so that we don't have to come every single time here in this parliament to fix what nonsense would have taken place before. And, Madam President, as I was on the point that this epidemic of firearms is nothing new. The Attorney General quoted the figures. Look at this. When you look at machine guns for the 10-year period 2009 to 2019, the Attorney General told us the figures were 44 as of June. I have 43 as of May. So that means there was one extra submachine gun that was found in Trinidad and Tobago in the year of 2019. But let's look at the last 3 years. In 2017, there was 0 machine guns. 2018, 0. 2019, 0. In 2017, with respect to submachine guns, there was a find of 23, there was a find of 14 in 2018, and a find of 7 in 2019, Madam President. And yes, it is a problem. I agree with the Commissioner of Police that one of those submachine guns can take out dozens of lives in a few seconds. I agree with that. But how are these things happening in Trinidad and Tobago? Trinidad and Tobago does not manufacture firearms. We do not manufacture grenades. We do not manufacture bombs here, Madam President. We do not do that. It is because of the porous borders we have that we have a high influx and importation of firearms in this country, Madam President. Because when you look at the figures simply show that it is a booming trade. Crime is probably the most booming trade in Trinidad and Tobago because the government has not been able to arrest the situation. Now, the Attorney General also spoke of figures. He talks about the number of arrests. He spoke of the number of arrests with respect to reports of firearm-related offenses. As of June, 17,908. He spoke of arrests for possession of firearms, which was 5,900 as of June. He spoke of arrests under the Anti-Gang Act, Madam President. But you know what the Attorney General did not tell us? How many convictions were there for these offenses? We hear about the high number of arrests, but where are the convictions? How many of these persons have been sentenced? What was the sentence given to these persons? Because bail is not a deterrent in this country. It is the sentence that is imposed on a person who is convicted of crime should be the deterring factor with respect to a person going to commit crime. I say it again, that bail is not meant to be a punishment in this country. Bail is only to secure your attendance at a trial, Madam President. This government lambasted the opposition. They tell us that we are unpatriotic, that we don't support the legislation. Well, that is false, Madam President. The opposition has supported the government. That is why they have these particular amendments to the Bail Act. They have amendments, they have the Anti-Gang Act. But let's look at the effectiveness of what is going on with the Anti-Gang Act. Because you would agree that most of the gang-related offenses are committed through the use of firearms. And you have these high-powered rifles that are being found by the police. In 2016, you have 2 arrests. In 2018, you have 1 arrest. In 2019, you have 5 arrests. The Attorney General promised this country that they knew the gang leaders by name, by address, where it is lying, and they would have picked up everybody. The country had the presumption that once the bill was passed, they would have picked up all of the gangs, the gang members, and arrested them. Because that is what the Attorney General would have given the presumption of in this country. But look at what the figures show. 5 arrests in 2019 and no convictions. Madam President, we cannot continue like this. We simply cannot continue doing this and passing law without any effectiveness. You have the Commissioner of Police recently crying out that this government is not giving the police service resources and releases on time, Madam President. You have the Commissioner of Police crying out. But we have a plan. Part of our national transformation plan, Madam President, we indicated with respect to national security is to give the Commissioner of Police releases on a quarterly basis, Madam President, so that he doesn't have to come cap in hand with respect to this government begging for resources so that he can do the work to fight crime. Because we all agree that crime is probably the most important issue in this country. Persons are afraid of their lives in this country. On a daily basis, you have persons dodging bullet holes in this country, Madam President. And something must be done. But I want to say that passing law alone in this parliament is not enough. You must have a competent government, Madam President, in order to carry out the effectiveness of this particular piece of law. Madam President, this government, again, is this, and you see the types of law that they are passing. Most of the laws that they bring to this parliament is with respect to the restriction of certain fundamental rights and privileges guaranteed under the Constitution. And today, Madam President, when you look at the provision of this bill, basically what the government is doing is legislating a judicial discretion. They are legislating a judicial discretion by telling the court that once these persons are before you, you have no discretion, send them to prison on remand, Madam President. And under our Constitution, there's a doctrine that is well in place, which is the doctrine of separation of powers, where everybody, it means everybody stay in their section. Let the Parliament stay in their section, the judiciary stay in their section, and the executive stay in their section. And each institution must respect each other, Madam President, in this country. Every single one. So that when you hear things like the Prime Minister of this country and the Minister of National Security of this country attacking lawyers in this country, saying that lawyers are involved in criminal activities, well, I say, Madam President, if you have the information, lock them up. But do not make all of the lawyers in this country be painted as though that we are criminals and that we are supporting criminal activities in this country. Because we have to get locked up, Madam President, let me just say, on this side of the house, we have nobody on bail here. We have nobody on bail on this side of the house. I don't know if the government could boast of that. Madam President, we don't have anybody dollar whining in Tobago with persons on bail.
Senator Hussein, your contribution is now starting to go down a particular path. I would ask you to revert to the bill that is before the chamber, please.
Thank you very much, Madam President. Madam President, and you know that the Law Association of this country had to come out in defense of the lawyers. Because if you read the statement of the Law Association on the 2nd of November 2019, they acknowledged the fact of the Minister of National Security of this country attacking lawyers. We'll lock up the lawyers who are involved in the criminal activities, but do not paint the rest of us as criminals, Madam President. You cannot do that. You will be eroding the democratic institutions of this country. You cannot do that. Then you hear words from the Prime Minister always attacking the judiciary. Madam President, on political platforms, you go and you complain about the decisions that are being made by the court.
Just one second. Senator Hussein, please. Don't let me have to caution you again, okay?
You.
Confine yourself within the standing orders when you're making your presentation.
I'm so guided. Madam President, and it is the point coming out that we must have respect for each independent institution of this country. The executive must have respect for the judiciary of this country, Madam President. And when you look at what this Bail Act is going to do, is that, and I know my colleagues will expand on this point with respect to the considerations that a court will have with respect to granting bail. But Madam President, because there was an unfavorable decision, you cannot simply just come to the Parliament and ask the Parliament to legislate on that decision. Madam President, under the Bail Act, there are avenues in which both the defense and both the prosecution can use if they are dissatisfied with a decision of the court. Madam President, when you look at Section 11 of the Bail Act, Section 11 states that where a magistrate's court grants or refuses bail in criminal proceedings or imposes conditions in granting bail in criminal proceedings, the High Court may, on application by an accused person, so the defense or the prosecution, grant or refuse bail or vary the conditions. So, Madam President, you are seeing that there are avenues available to the state. But
just a courtesy call. I've asked the Clerk of the House to email out to all senators a consolidated version of the Bail Act as amended. It's now on your phones, your devices, so you can see the amendments into context. I thank the Honourable Senator for giving me.
you're welcome, Attorney General, but I have the version that you would have passed on to us. I did my own markup with respect to the assented act. Thank you very much. So, Madam President, you would see that there are avenues available. But what is not available to the police service is the resources. Because 95% of the prosecutions in this country is not done by the Office of the Director of Public Prosecutions. They are done by the Police Service of Trinidad and Tobago. The police will be the first port of call when it comes to these persons appearing before the magistrate, charged with these offenses of trafficking and prohibited weapons. They would be the first ones interacting with the court. The government must take the step, the active decision, to give the police the resources of additional attorneys to help the prosecuting police officers in the court, Madam President. Because the police officers simply cannot do it by themselves. They need the assistance of the state. And I'm pleading with the government to give the assistance to the police officers in the courts of Trinidad and Tobago. Because those police officers do very good service, Madam President, when it comes to prosecution. They do very good service. But I think, Madam President, they require the additional assistance from the state. Now, we must look, when we look at legislation in this parliament, we must look at the benefits of the legislation. So the ultimate aim of this is to get those persons who are charged with these offenses off the street. That is really what this bill is about. But you must also look at the disadvantages. You look at the cons with respect to passing legislation, because you must weigh the both. The Attorney General speaks of the test of proportionality. You must look at the proportionality with respect to the legislative aim. Let us weigh the advantages, let us weigh the disadvantages. So what are the disadvantages of this bill? Madam President, this particular piece of legislation is denying bail, and I'm going to repeat it again, for persons charged with for the first time in their life. The first time in their life they're going to be charged. So once they're charged in the possession of 2 or more weapons, and let me put this in context, is that they don't need to have the weapons on their person. As long as they're in the same car, for example, or they're in the same house, and weapons are found in the house, they are deemed to have in their possession those particular articles, Madam President. So there's deeming provisions with respect to the trafficking, Section 9A of the Firearms Act. You are deemed to have these weapons in your possession. And once there's a deeming provision, what happens is that the burden of proof reverses on the accused person. So there's a reversal of burden so that the person now has to prove that, 1, I had no knowledge of these firearms, and 2, that those firearms were not in my control. But at what stage that happens? That happens at the stage of a trial, which comes almost 10 years after you have been charged. So, Madam President, we can see that there can be misconduct and misuse of this particular piece of legislation. And it's no secret. Madam President, we are looking at things like automatic firearms, grenades and bombs. This country knows what happened to Mr. Sadiq Baksh. Had this bill been enforced then, Mr. Sadiq Baksh would have been in jail for 120 days, Madam President. No previous conviction, no pending charge. You found missiles in your water tank, you were sleeping in your house, and you are going to be denied bail for 120 days, Madam President. 120 days, Madam President. 120 days.
Jail politicians.
Let me look at another.
Obika, may I remind you that you must listen to the contribution in silence, please. Continue, Senator Hussain.
Thank you very much, Madam President. Madam President, the concern is real. There are judicial decisions in this court where they have found that the police has planted illegal substances in persons' property. There's one case in particular, Anisha Rafik against the Attorney General, CV 2017-01077. And in that case, if you would allow me to quote, Madam President, from page 75 of the written judgment by Justice Margaret Mohammed, she said that the allegation of fabrication and planting of evidence by police officers is a serious matter. I am satisfied that there was cogent and compelling evidence that the black plastic bag containing the alleged cocaine was planted by the police officer who searched the middle bedroom since they had the opportunity to do so, as no occupant from the house was present during the search of the middle bedroom. So the judge went on to also give the factual matrix with respect to how the police would have planted drugs in someone's home. Now, yes, the facts may be different in this case, but what stops any person or any police officer from planting any firearm in your property, Madam President? And you know who bears the burden when these misconduct happen? It is the taxpayers of this country. Because in this case, Anisha Rafik, she was awarded, Madam President, $220,000 with an additional $20,000 in exemplary damages. All because of what? Misconduct by the police officers in this case, Madam President. That is what it is. Madam President, recently in the newspaper, you see in the Guardian dated 14th of December 2016, siblings freed as police fabricated evidence. This is from the Guardian, where two siblings, Madam President, were freed based on, again, illegal drugs being planted in their homes. Magistrate Cardenas Raghunandan said she believed that their claims over the police officers' claims, and she found them both not guilty. Madam President, this is a real situation, and I want to commend this morning Senator Vieira, because Senator Vieira saw something and he informed this Parliament, Madam President, when we were debating Act 17 of 2019 in June of this year. Senator Vieira piloted a very essential and a very important amendment, a safeguard, in fact, Madam President. Senator Vieira spoke of creating offenses of frame-up. That's the offense, frame-up, Madam President. So that you create a deterrent so that the police officers would not do these things, or ordinary citizens, because they have a vendetta against you. And I think we need to put some more safeguard with respect to this particular clause, because this can be used for misconduct, Madam President. It is very worrying. Also, when you look at the Police Complaints Authority, they must be more robust with respect to dealing with errant officers in this country. I'm not casting any aspersions on the Trinidad and Tobago Police Service, but every group there are rotten apples, Madam President. Now, I raised a point earlier on with respect to border control. And border control in this country, Madam President, is a serious issue. Because in this Parliament, we are passing laws to deny bail for those firearms. But how does the firearm get here? How does it get on the street? We have passed several pieces of legislation in this House dealing with follow the money, follow the money, follow the money. We have passed laws because in order to acquire these firearms, you must have resources. The criminals are resourced. But we must stop the importation, we must stop the product from flowing into the borders. When you look recently, Madam President, as recent as of this morning, if you read the Trinidad and Tobago Guardian, you would have seen a headline, state loses US $10 million appeal over the maintenance of the helicopter fleet. And this has to do, Madam President, with the helicopters that would have been charged with the responsibility of monitoring the borders. Madam President, there were 4 helicopters that were purchased by a previous PNM government, together with the particular maintenance contract. When this new government was installed, the maintenance contract was not renewed. So there was interim arrangements, Madam President. Come up to 2017, interim. Do you know that the government awarded a contract to the same foreign company to maintain the fleets for 2 years? The Minister of National Security at that time, 2017, awarded a contract to maintain the aircraft for 2 years. Then they told the foreign company, no, we want to reduce it to 1 year. While at all of this time, the company was servicing and maintaining the aircrafts. The company subsequently sued the government because they have not been paid. Madam President, would you know that today this country is $10 million poorer because the Office of the Attorney General of this country did not file a defense in time in that particular matter?
What?
A defense was not filed. Madam President, after 3 extensions were given,
Negligent.
a defense was not filed in that matter. The people of Trinidad and Tobago today is poorer by $10 million, Madam President, because the negligence, the omission of the Office of the Attorney General of this country, Madam President. You know, they use an excuse why they didn't file a defense is because they was moving from Cabildo to the new tower.
Now, Senator Hosein, you started making reference to the decision by making reference to porous borders. Now you're going into the decision with absolutely no reference. You're making no link to the matter at hand.
May I, Madam President?
Well, no, you may continue in your presentation by maintaining relevance, okay?
Thank you very much, Madam President. And the point is that those helicopters are down because of a decision made by this government not to maintain them. Madam President, so you have no helicopters now, and you have to pay $60 million today, and interest also, and you have nothing. But what is even more funny about the situation and worrying is that, you know, the Office of the Attorney General went to argue in the Court of Appeal that the contract they awarded was illegal because it breached the Central Tenders Board. That is the defense that they use, that they awarded an illegal contract, basically, that is not with respect to following the provisions
Senator
of the
Hussain,
tendering rules.
You're not following my guidance. I will ask you to move on, please.
Sure, Madam President. Madam President, I'm finished with the Air Guard. I'm going to the Coast Guard now, Madam President, with respect to the porous borders. This government has done absolutely nothing to maintain the Coast Guard vessels, the 12 Damon vessels, Madam President. They have done nothing, Madam President. Imagine we have to wait until 2020 to get some Coast Guard vessels in this country to protect our borders from Australia. And we are not even certain that we will get those vessels delivered on time because this PNM government is only about talk, talk, and more talk, Madam President. But I saw the Minister of National Security was joyriding, he had a boat ride with the members of the media all around Trinidad recently, showing them how far Venezuela is from Trinidad and those sorts of things. But Madam President, he would never issue a statement with respect to when we are going to get all of the fleets back up. And they will continue to, I'm sure one of them will stand up and talk about the OPVs. But it was a Kamala Prasad government that recovered over $1 billion for the people of Trinidad and Tobago with respect to that failed OPV deal, Madam President, through arbitration. We recovered that to the people of Trinidad and Tobago. And they will continue to say that we get rid of the OPV, but I am sure that the OPVs would have ended up in the same situation as the 4 helicopters because this government would not have been able to maintain those particular vessels. It would have run to the ground. It would have run to the ground. And you must also have consideration to what is happening with our neighbors. You have Venezuela right there, and you had thousands of Venezuelans passing through our borders. So you can imagine how easy it is for guns and other items that are illegal to pass through our borders. It took 10 days for this government to register 16,000 Venezuelans. But it had some gathering in the savannah, and I hear they register 18,000 of them in a few hours. Madam President, I will move on.
I would ask you to really be relevant to the matter at hand, and please,
Sure.
I don't want to have to interrupt you again.
Sure, Madam President. Madam President, you should have been there, you would have seen. Madam President, you would have seen, Madam President, Trinidad and Tobago is a unique island with respect to our laws and our constitution. But when we look at our neighbors like Jamaica, and in particular, they had passed a bill in 2010, July 22nd of 2010, and that bill was cited as the Bail Interim Provisions for Specified Offences Act of 2010. And in that particular piece of legislation, Madam President, you would have seen that they would have put a sunset clause on the bill because they know of the importance of the restriction. Their sunset clause is actually 1 year. It's just 1 year. Then the second issue I want to raise with this is that while we had put in a section 7A in our bail act that bail will only be granted in exceptional circumstances, what the Jamaicans did is that they said they created a lower standard. They said a person who is charged with any of the offense specified in the schedule and who has not on a previous occasion been convicted of any offense specified in the schedule shall be entitled to be granted bail only if that person satisfies the court that bail should be granted. So it's a much lower standard than proving exceptional circumstances, Madam President. The third point with respect to the Jamaican experience is that in the Jamaican legislation, there is a review relating to persons held under that, under the mandatory denial of bail. And it says that a person who is held in custody without bail under Section 3 of that Act shall be brought before the court at the interval specified in subsection 2 for the court to review the question of whether the person should continue to be held in custody or the grant of bail should be considered in relation to the offense by virtue of which the person has been held in custody under that section. And they said that the intervals should not be more than 7 days after the person is first charged with the offense concerned or thereafter subject to the determination of any review under subsection 1 at intervals not exceeding 14 days until the 60-day period referred to in section 3A expires. So you see what Jamaica did. Jamaica gave the opportunity for a constant review of bail with persons who are denied mandatorily. So while Trinidad denies bail for a period of 120 days, Jamaica denies for 60 days. While Trinidad and Tobago, there's no review of your bail for that 120 days, Jamaica has a review of your bail every 14 days, Madam President. So you see the difference with respect to how this takes place and protecting the fundamental rights, because it's a balancing exercise. Because when you remove the right, you must also give the accused something also to show that there's proportionality. And Madam President, we must never forget that the golden thread runs through every democratic society is that a person is
Senator Hosein, I apologize. You have 4 more minutes.
Thank you. That a person is presumed to be innocent. A person is presumed innocent until found otherwise, Madam President. So you cannot impose these harsh restrictive measures on a person when they are presumed to be innocent in this country. But I don't know, I might anticipate the Attorney General, but I know he comes with a usual menu of what the government did. He boasts of the achievements of his office for the 4 years that has gone. And the Attorney General will look at the court system. And the first thing he will talk about is the criminal division, the creation of the criminal division. But I would like to report on what happens in the criminal division. Most of the courts of this country that has to enforce this bail bill, there are no magistrates. The Tunapuna court has no air conditioning for months. Princestown is without a court. Point 14, courts are held in the police station. In San Fernando, there's no magistrate, no house for the magistrate court. They're squatting at the High Court, Madam President. The Attorney General will boast of the Children's Court, that they established the Children's Court. But I want to remind the Attorney General that it started under the United National Congress government led by Kamala Prasad Bissessa. So the Attorney General is benefiting from the work that we have done, Madam President. You would hear about moving out of trafficking cases. Not a single case, those traffic offenses, was moved from the magistrate court. You will hear talks about preliminary inquiries. Not a single one has yet been abolished by this government. You will hear the Attorney General boast about 400 MSIs. 400 MSIs. Do you know who is responsible for MSIs in this country? It means maximum sentence indication. It is the judiciary. There was a case called the Goodyear case, the Goodyear hearing, where the court is empowered to make a deal with the accused that saying, this will be your maximum sentence. This was nothing, no creation of the government. This was a creation of the judiciary, but the government continues to put it as part of their achievements, Madam President. That is misleading. That is misleading. And it shows, Madam President, that they are taking credit for work done by the judiciary that they had nothing to do with.
Senator Hosein, you have 2 more minutes. May I advise you
I'm winding up, Madam President.
But wind up in a relevant manner,
Sure,
please.
Madam President, because you would have understood, because with the maximum security sentence indications, those would be very valuable to persons who are charged under these trafficking offenses or possession offenses. But Madam President, the point is that this government is desperate for achievements. They're desperate for achievements. And you will see, Madam President, that they will go all over this country to boast and cut ribbon all over the place, mama guy and the people, but they have achieved nothing. They are all about talk, Madam President. Talk, talk, talk. But Madam President, talk done. Everybody knows that the UNC works. I thank you very much.
Senator Vieira.
Thank you, Madam President. And like Minister Baptiste Primus, may I also join in welcoming you back. I did. Madam President, let us not be beguiled by the brevity of this bill. Its potential implications and consequences are enormous. I would say this bill needs to be handled like one of the hand grenades mentioned at Clause 3B. Now, my contribution should not be taken as a rebuke or criticism of the government. The Attorney General, the Honorable Attorney General, loves the law as much as I do, and I am hopeful that after hearing our concerns and contributions, he will give serious consideration to our recommendations. All of us are committed to getting dangerous weapons off the streets. That's a given. There can be no lawful justification for an ordinary citizen to be in possession of automatic firearms, grenades, bombs, artillery. In fact, left to me, there would be no guns in Trinidad and Tobago. I read recently a major global report which confirms that gun-related homicides, suicides, and accidents are failing after the introduction of anti-gun laws in places like Australia, Brazil, and South Africa. So there is empirical evidence that tougher gun laws do work. But my concern with this bill has to do with the risk of unintended consequences and the deprivation of the court's discretion. Now, I have previously raised concerns about weapons and drugs being planted on persons or in and around their premises. And in fact, for me, the core issue in this bill has to do with the possession of a prohibited weapon and how that gels with Section 7A. Ultimately, it's going to boil down as to whether Section 7A is the antidote, as claimed by the Honorable Attorney General, to a person wrongfully charged with being in possession. But I'm going to come back to that. Senator Hosein talked about the instance with Shadiq Bash. Now, if we bring our minds back to what happened on that occasion, he was charged with being in possession of missiles and narcotics in his water tank. Now, I have water tanks at my home, and they're not near my house, they're up by the road. And I could tell you, when police do searches of premises, they would never think of going and looking in a water tank. It just doesn't factor in the normal search of a premises. The only way you will go and look in a water tank is if somebody tipped you off, told you go and look in a water tank. So, as Senator Hosein points out, if Mr. Bash had been charged for possession of those missiles and drugs under this legislation, no ifs or buts about it, he would be incarcerated for 120 days. Court has no discretion. That's a real concern for me. And why is it a real concern? Because as these tougher laws begin to bite and to take hold, the bad guys are going to get more desperate and they're going to get more creative. Now, I understand the genuine frustration. I understand even the anger felt by the public, by law enforcement, by government, when persons charged with serious offenses are led back on the streets. But we also must respect the ideal that the judiciary must be responsible for establishing guidelines and criteria on bail and sentencing. We should not let one or two instances of purportedly perverse decisions be taken or treated as the norm. Rather, they present us with an opportunity for us to better understand and to appreciate the nature of discretionary powers. Something that we as legislators must always be mindful of when trying to determine what is the correct legislative approach. We should seek to understand and appreciate the difficulties faced by magistrates when trying to apply broad discretionary powers into decisions in individual cases. What help, if any help, is available to them in identifying the right principles and making the right judgment calls in the heat of the moment, under pressure from seasoned, high-powered attorneys, who, by the way, are also just doing their jobs? Each case is different. And because discretion includes weighing factors such as the relevant facts, past criminal history, flight risk, potential danger to victims, the relevant law, seriousness of the charges, there is always going to be the risk of piecemeal and unsystematic decisions when setting bail to suit the particular circumstances. But it's taking away the court's discretion to grant bail on a charge of possession for a first-time offender or any possession charge the best or only solution? How does removing the court's discretion gel with the separation of powers? The Attorney General spoke about the separation of powers principle, the need for proportionality. Well, let's drill down into those things. In the common law system, all exercise of official power must have a legal basis. And it is the courts that lay claim to having final authority in deciding the legality of any action. It is the courts that must have final say on any matter pertaining to the fundamental rights and freedoms of individuals. Now, we understand the problem government is facing on crime and what they want to solve. We understand the need for these tough gun laws. And we all want the same outcome, to protect society from dangerous people. Yes, Parliament has the powers to make laws for the peace, good government, and order of the country. But I would suggest we must be careful not to sacrifice process on the altar of desired outcome. Yes, feelings can vary, perspectives can vary from person to person, magistrate to magistrate. Yes, due to the choice in discretion, there's always a danger that discretionary powers can be used mistakenly or inappropriately. Yes, decisions can be made based on irrelevant factors. Yes, discretion can fall short because the decision maker was mistaken or he made the wrong judgment call. But is the answer to remove the court's discretion altogether on a charge for possession? In a democracy, the executive is elected by the majority to implement its political program. Yes, government has gotten tough on crime.
You said quite importantly that the antidote may be in 7A, but you're making a very strong submission over and over that we're removing the discretion of the court completely. May I ask you, if you don't mind, to just clarify that point?
Absolutely. Thank you, Attorney General. But if, as a good lawyer, you have anticipated where I am going, but it really has to deal with what constitutes an exceptional circumstance. And that is the rub with Section 7A I'm going to come back to that, but that's where I'm going. Yes, so government has gotten tough on crime. And one understands the impatience and the frustration on the part of some because lawyers and the courts seem to be out of step or not cooperating with the democratic will of the people. But I want to remind you, democracy is not only about fulfilling the will of the majority, the police and the government. It is also operating government within frameworks of norms and values, collective and individual human rights. Democracy and justice requires us, when making laws for the peace, order, and good government of the country, not to drop the ball. Not to drop the ball where protecting and safeguarding the rights of the individual is concerned. When our courts make decisions aimed at safeguarding fundamental values and protecting the rights of the individual, they are also supporting democracy. I have no doubt that in 99% of the cases, the person charged with being in possession of a prohibited weapon is a bad guy who needs to be kept off of the streets. But that's no comfort to the innocent person who is charged and wrongly incarcerated. Because this law says you will be denied bail on just a charge. We're going to come down to the 7A. But what if the accused was tricked into carrying or taking possession of something he was unaware of? You're an Uber driver or something like that. What if the accused had let someone else use or occupy his property? You're renting, you're lending to a friend without realizing what would have been put into the property. People have lockers, people have businesses where they rent locker spaces. All of these people are potential victims of setup. I spoke in the past about accused persons being framed. This is not an unusual and an exceptional thing in Trinidad and Tobago. It happens. I've been in a number of cases where people were framed. What if the accused is being coerced by threats of violence to himself or his family? You know, you've been made to become a mule because somebody says if you don't do this, your family is going to be hurt or something's going to happen to you. So we have to consider the possibility of unintended consequences. In particular, the very real risk that an innocent person may be wrongly charged. Even where the odds of that happening may be just 1 in 100. It would not be right for an innocent person to have to languish for 120 days in jail, to be denied bail without recourse to judicial intervention and relief. Now, let's look at section 7A. Because what we've done is we have expanded the list of the specified offenses, and as Senator Hosein pointed out, none of us have any problem with all the other list of specified offenses. Because when we agreed to 7A in the context of those other offenses, there was already evidence that the accused was a potential threat. He was a risk. He had pending charges. He's in the course of committing some crime. This is a different scenario. Here you are just being charged with being in simple possession. There's no pending charge. You've not committed a further offense. This is a serious situation now because you, as I say, could be set up. So what does 7A say? Notwithstanding subsections 3 and 7, a person to whom these subsections apply may, in exceptional circumstances, make an application to a court for bail. Well, when I think about exceptional circumstances and I recall that debate, we were talking about softening the harshness of this section so that a person, even somebody who has pending charges and is a bad guy on the face of it, could get relief if there's a medical emergency. He had a heart attack. He had some particular situation. Now, is a charge of possession going to qualify as an exceptional circumstance? I don't see it. You're charged with being in possession. What's exceptional about that? So I am going to recommend that we soften or we expand 7A so that a person aggrieved by a denial of access to bail under subsection 3AC, which is this, may make an application to the court for bail. That's my real bugbear with this act. It's the only thing that has to do with the possession aspect. We should be uncomfortable. In fact, we should all be very concerned about any legislation which seeks to exclude the court or to take away its discretion. Right? As far as I'm concerned, once the liberty of the subject is at risk, the courts must have the final say. When it comes to fundamental rights and freedoms, our courts must always have power to review and intervene as necessary or appropriate. I have supported all the tougher gun laws and legislation, but I am very concerned about the real risk that an innocent person may be put in a situation. And when I say it, I'm not looking to put goat mouth on anybody, but it could happen to any of us.
Because we're in the middle of this, again, thank you for giving me. It is never the circumstance as drafted or as intended, and perhaps I just ought to say this, that the exceptional circumstance in section 57A will be the mere fact of being charged for trafficking or possession. The exceptional circumstance is anything in the individual case which means that a court ought to consider. A youth, I don't live there, constructive possession, the aggravation of the point, etc. So it isn't ever the circumstance that the mere charge would be that. But respectfully, if the position is that we ought to just allow the access to bail, then effectively you're saying withdraw the bill.
No.
Thank you.
No, AG. With respect, I am saying that in so far as we are talking about clause 3, was it? 3AC, that my recommendation is that with respect to clause 3AC, a person may make an application to the court for bail. All the other offenses will go under the exceptional circumstance. I didn't have access to researching case law and precedent on exceptional circumstance, but when I Googled what constitutes exceptional circumstances, conditions required so as to alleviate or mitigate unforeseen or unconventional hardship. Well, that does not cover the possession charge. That, to my mind, is in keeping with my understanding of what exceptional circumstances means. So I think there is a very real danger that Section 7A does not address. As I say, and I think not just for this bill, but we must always be mindful of the importance of judicial discretion. It is fundamental in the functioning of our criminal justice system. There will inevitably be tensions between the executive and the courts. But we as lawmakers, we must strive to always maintain the separation of powers while assisting the executive and law enforcement to carry out their respective duties effectively. No part of the Bail Act, in my respectful submission, should operate as a court-free zone. I thank you.
Minister of National Security.
Thank you very much, Madam President. Madam President, good afternoon. It's always a pleasure to come to this House to contribute. And I find myself here once again contributing on what we see as a very important piece of legislation. I was fortunate enough in my scrambling before coming to the Senate to listen to the normal and usual, very sensible contribution of Senator Vieira. I heard some of the previous contributions by the opposition. Madam President, it brings me absolutely no pleasure and no joy to come to the Senate here today to deal with this particular piece of legislation. But I want the opportunity, and I'm grateful for it, to put this particular piece of legislation into the reality of the setting of Trinidad and Tobago. Because fortunately, for the vast majority, if not all, of those who sit in the Senate, I think save for my colleague, the Attorney General, who sits on the National Security Council, a lot of people, including the vast majority of the public of Trinidad and Tobago and the vast majority of the members of the Senate, don't have to deal or face the reality of what it is that we're really facing out there. Because like Senator Vieira, I agree with him. In the practice of law, we're all about the protection of rights. I heard you talk about the water tanks up on the hill and what are the realities, etc. Madam President, unfortunately, the reality of what we're facing today in the national security realm and spectrum is extremely frightening. Yesterday, I chaired a meeting with the heads of all of the divisions and their second-in-commands of the Trinidad and Tobago Police Service. Of those divisions, that the murder rates and the use of violent crime, in our opinion, are at risk of running away. In that meeting, I had the Chief of Defense Staff and his head of operations, head of intelligence. I had the intelligence services. And it is always coming out of those meetings that as a citizen of Trinidad and Tobago, I'm most disturbed. Because you see, the reality of what we're facing there, out on the streets, is very different, fortunately, for the vast majority of Trinidad and Tobago, to what we know as reality. Because you see, perception is reality. So reading about crime in the newspapers, seeing reports of criminal activity on television is very, very different, I'd like to suggest, from when you feel, touch, and are exposed to crime. I think I can say without fear of contradiction that 99.9% of the people in this chamber are fortunate never to have read more than one intelligence report about persons who have been provided with AR-15s with the task of going to murder someone. 99.9% of the people sitting in this Senate, fortunately for us, have not received a briefing that there is a real and present danger and threat to their life and their family's life by the criminal element, who we now know are in possession of automatic weapons, sophisticated handguns, and assault rifles. And this piece of legislation here today, colleagues, with the greatest of respect, is designated to deal exactly with that, and specifically with it. It is very easy for someone on the outside to sit down and say, but when I look at the charges that a person has been charged with, I don't see 9 AR-15s, being in possession of 9 AR-15s. And just to remind the population, as well as the honorable members in the Senate, what an AR-15 is. It is a weapon of war. Every time we turn on our international news and we see mass shootings and the murders of more than 10 people in the United States, for example, the one that took place in Las Vegas with someone in a hotel room hundreds of meters away from a concert taking place where people are enjoying themselves, and the aftermath of the room when the authorities got into the room and found empty magazines and tons of 5.56 ammunition. It was an AR-15 being used. What happened in El Paso, Texas, outside of our Walmart? It was an AR-15 being used. In Trinidad and Tobago, lest anyone does not get the reality of what we're facing in national security, the criminal element is now in possession of AR-15s. And I guarantee everyone in this Senate here today, Madam President, without fear of contradiction, that God forbid any one of you or your family members are told that criminal X has been put into possession of AR-15s to kill you how you would feel at night, how you would feel walking in the road on a daily basis. Because you see, the reality of what we are facing in this country, in Belmont, Madam President, my constituency, in an area that I walk in constantly, the St. Francois Valley Road, HDC, plannings, the housing, HDC housing on St. Francois Valley Road in Belmont. God intervened and we recovered 9 AR-15s. And to show you how sophisticated the criminal element is, they did not have them put together. Anyone who knows anything about firearms knows you can dismantle and put into pieces an AR-15 or any firearm whatsoever, a simple handgun. Those 9 AR-15s were soon followed by the recovery again, fortunately God intervened, of 8 AR-15s in 4 roads a few weeks later. And I tell you, the members of this Senate, with the greatest of respect, and the population of Trinidad and Tobago who are listening, with the greatest of respect, one of the things we've been doing in national security is trying to analyze and decipher where these AR-15s have come from, who is in possession of these AR-15s, and what for. Because you see, Madam President, it is easy to talk about being in mere possession of an illegal firearm. That is a nice academic concept, with the greatest of respect, because I put it to this Senate and to everyone in Trinidad and Tobago. There is absolutely no legitimate reason whatsoever to be in possession of an illegal firearm. As I've said here before and in the other place, the only reason a person is in possession of a firearm is to kill somebody. A firearm is not a toy. A firearm is not... Senator Vieira, you want me to give way? Please.
I am totally in support of the amendment to make those firearms, bombs and stuff prohibited. My only concern is that in respect of that possession charge, there should be a right to review by a court. I'm not shooting down the proposal.
No pun intended. Thank you very much, Senator Vieira. I wasn't responding directly to the point you had raised on possession, but I'm putting it on the record once again, lest anybody misses the point. There can be no legitimate reason to be in possession of a firearm. These firearms have the ability to kill masses and multitudes of people. Unfortunately for us in Trinidad and Tobago, it is a reality. And it has been a reality since 1990. Because I believe everybody sitting here today would be aware of what happened in the House of Parliament in Trinidad and Tobago in 1990. And that changed the landscape of Trinidad and Tobago. Every time I sit and meet with all of the international agencies, and I have to explain what it is we face in Trinidad and Tobago, and try to dissuade their mind that a certain religious part of our brothers and sisters in society in Trinidad and Tobago, our Muslim brothers and sisters in society in Trinidad and Tobago, are not terrorists. I tell them what happened in 1990 in Trinidad and Tobago that changed the landscape was after that it changed the psyche of the people of Trinidad and Tobago. But you will all remember storming Parliament on the 27th of July 1990. Those involved, thank you, those involved had assault rifles. What is frightening today is what exists out there, and we're not only talking about assault rifles. And I put it to this honorable Senate that anyone who is in possession of an illegal firearm can only be in possession of it because at some stage they intend to harm or to kill someone. Because when you point an AR-15 at someone and you pull that trigger, the type of round that shoots out of it will kill you. A handgun, you have an opportunity to escape. and I'm putting it here in this house on record on the Hansard on the 12th of November 2019, a bulletproof vest is not going to stop the round of an assault rifle. Understand that. Understand the seriousness of this piece of legislation today. So a person found in possession of 9 AR-15s, and then us finding 8 AR-15s, and then last week, 2 individuals dressed in police uniform, in a vehicle with blue lights, in possession of the same Glock handgun I've been talking about, as well as an AR-15 with 2 magazines of rounds. That is not someone, with the greatest of respect, any civic-minded or right-minded or legal citizen of Trinidad and Tobago should want to see out on the road, out on the streets. I'm sorry to say it, but it is the reality. I heard reference to Jamaica. Let us not be fooled by what takes place in Jamaica. We are fighting hard in national security to make sure we don't get anywhere near to what our brothers and sisters are facing in Jamaica. Their murder rate is over 1,800 a year. They have legislation for the last 3 years that allow them to go to Parliament to declare an area a state of emergency. And when that was raised here, I opposed it. Because you know why? I knew it wouldn't work. A state of emergency does not work. It is an acceptance that there is nothing left behind you. And I stood with the men and women in our security services and apparatus and said, under my watch, that will not happen, because we have not exhausted every single opportunity and every single operation we can do legally within the parameters of the law to fight the scourge of what is going on out there. But this, and I also promised them at the time that I would work with the Attorney General to see what legislation we can bring to make their jobs easier. Because let me, with the greatest of respect, tell everyone in this Senate, as a police officer or member of the Defense Force or the intelligence services, when you go out there and you put your life literally at risk, and you find 9 AR-15s, 9 weapons of war, 9 machine guns, and then on the first occasion that comes up, and someone exercises a discretion to grant bail and put them out for $500,000, why should you go back out the next day and look for the same people and take the fight to the same criminals? Has anyone here ever faced the instance where you have been a victim of crime, been held up at gunpoint, someone has come to kill you in the worst case scenario, they are captured with an illegal firearm in their possession? So like where Senator Dookie is, standing here facing me, the police hold me, the perpetrator, going to do harm to Senator Dookie. And then I appear in court on the first day, tell the magistrate I'm not guilty to the 9 firearms that Faris Al-Rawi held me with. $500,000 is small change for a seasoned criminal. And they don't even have to come up with the $500,000. Huh? That is not how bail works. And the next day, I am out. And I come and I stand up next to Senator Dookie. I say, Dookie, how you going, man? That 9 was only half of the cashier, the 18 I have. I'll see you at your home. That is the reality of what Trinidad and Tobago faces. And the reality of what Trinidad and Tobago faces with the possession of illegal firearms. And if I have any interruption today, I'll talk about a different type of reality. I'll talk about the reality of who interfacing with the criminal element out there and what it is they're talking about. But with the possession of these illegal firearms that I've come to discuss today, let me put it. I'll see when last Raji speak to you. The possession of illegal firearms, the crime statistics that were discussed at length yesterday with the heads of the divisions of the police services in Trinidad and Tobago as we take the fight to the criminals. And they are the ones who have asked the Attorney General and myself to look at this legislation, pleaded with us as they go about picking up the illegal firearms, what it is they're facing. Madam President, Trinidad and Tobago Police Service crime statistics dated the 11th of November. These are the statistics that we as citizens of Trinidad and Tobago face as of yesterday, given to me by the Commissioner of Police in our weekly meeting. And I start with the monthly comparative of firearms found and seized. As at yesterday, in Trinidad and Tobago for the year from the 1st of January to the 31st of October 2019, the police service have seized 841 illegal firearms. 841 illegal firearms. And in some months, when you look at the frightening numbers, and this is compared to last year, 702. And I heard some discourse about the borders. Absolutely correct. We are fighting to keep the borders more secure. Last week, I took the media out on a Coast Guard vessel for them to see for themselves, because lest they be misled at what it really means. 7 miles of coastline separating us from South America. Lest there anyone, just look outside here during your lunch break, members, I ask you, and see that wide expanse. And when you're outside there, the media could not even pick up the pirogues that were off in the horizon. Murders, shootings and woundings, illegal firearms found and seized. When you look at the woundings and shootings by divisions, that is how we're targeting and what we're doing. And let me tell people, through you, Madam President, the firearms and ammunition found and seized from the 1st of January to the 11th of November for this year in Port of Spain. Last year at this time, found and seized 75. This year, 71. In Port of Spain, we are in Port of Spain. The rounds of ammunition for the same time last year, 1,500 rounds of ammunition. This year, 1,192. That is in a single division. For the whole year last year at this time, we found and seized 15,278 rounds. Every single round of ammunition is created to kill somebody. 15,000 is what we found and seized. How much more is outside there, God forbid, to hurt and harm any law-abiding citizen of Trinidad and Tobago? As at this year, 9,828. As at this year, we have seized 716 illegal firearms. 873 were seized at the same time last year. In the Southern Division, last year, 127 illegal firearms. As at this time this year, 104. This year in the Northern Division, the East-West Corridor, last year, 170 illegal firearms seized, 148 this year. These are the startling statistics, and every illegal firearm is in a criminal's hand, designed to harm somebody, designed to kill somebody. Those are not the types of individuals that any civic-minded, sensible, law-abiding citizen of Trinidad and Tobago would want out on the street. Because as politicians, unfortunately those in the Senate don't face this, but as any elected member of Parliament would tell you, when you go out and interface with the people out there who have put you into Parliament via democracy and elections, you go and tell them, you think a criminal who has just been held with 9 AR-15s, guns of war, should be put out back onto the street the same day of their first court appearance? Go and tell them that. Go and tell a person who has lost members of their family as a result of illegal firearm activity, who are living in a community traumatized by illegal firearms and the criminal element using it. The other day, Madam President, I walked in La Horquetta because we launched an operation, and I was shocked being on the ground there. It is such a well thought out community. Every second block, there was a recreational facility. I have seen that nowhere else in Trinidad and Tobago. But whilst walking, the police took me to the corner where the week before, a man was murdered who had just come from the tuck shop, less than a block down. And I saw a man's motor vehicle with a patch on it. And they said that man's motor vehicle on that corner was shot with an AR-15 that the bandits used, the criminals used to kill the man, another person. And his children had just come out of the house to get in the vehicle to go to their afternoon lessons. Go and tell that man and his family, who are law-abiding citizens of Trinidad and Tobago, that it is okay for the criminals we've held with the firearms, the illegal firearms, to come back on the street and stand up next to him, rather than going to prison. And we are now under, we meaning the state, under an obligation to get their trials started within 128 days and to have it proceed and be completed within the space of a year. It's nice to talk about who should be out on bail and these types of things. That is not the reality of what we face in Trinidad and Tobago. Murders by motive, not woundings, murders by motive. Unfortunately, as at the 11th of November, we've had 455 murders. But I want the honorable members of the Senate to understand, out of that, 144 definitely gang-related, 60 revenge, 53 drug-related. You then have things like altercation, and 69 unknown. So 56.5 of the murders we have been able to say are related to gang activity by the use of firearms, right? Gang-related murders, total murders and woundings and shootings by division. On the record here, through you, Madam President, I place on the Hansard that as of yesterday, 80.2 of the murders committed were committed with the use of firearms. And think, out of those murders, how many did you read in the newspaper was somebody with a legal firearm? Right? 88.2% of the murders were committed using firearms. I would hazard to say, out of that 80.2, 80% of that 80.2 is through the use of illegal firearms. Shootings and woundings. In 2018, there were 482 woundings and shootings, as at the same time in November, while 625 were recorded in 2019. That is like a war zone. 625 as at yesterday, woundings and shootings completed in Trinidad and Tobago. When we look back 10, 15 years ago, the figures were much lower than this. What we have to do as legislators, with the greatest respect, senators, is we have to move with the times. We have to understand the reality of what it is outside there. I practiced for many years. My first case at the Privy Council was a human rights case. Matthews, all about death penalty and whether hanging should be mandatory. I am not coming here today, with the greatest of respect, to make these pleas and submissions with you, honorable members, on the basis of any politics. I am coming here today as a concerned citizen of Trinidad and Tobago, someone who has young children, someone who intends to spend the rest of my life here. God give me life. But today we are being called upon, Madam President, through you, to keep persons who are in possession of tools of war designed to kill people off of the streets, and not to languish and be lost in prison. They can go to the court if they want their bail, they want to make an application for bail. But more importantly, give us the opportunity, because you can't build, as I have been telling the police service, unfortunately, you can't build that case and that evidence as quickly as we would like, because people are afraid None of us here, nobody here is living in a community where every single night there are people walking up and down the streets with automatic firearms shooting people.
Thank you, Honourable Minister, Honourable Senators. As I indicated before, there is a ceremony that will take place shortly with the UN, the pins for the Sustainable Development Goals. There are some excellent young people there, anxious and excited to give the pins to members of Parliament. That ceremony is going to take place at 1 o'clock. So I'm going to suspend now, and we will come back because I'm such a generous person at 2:15. So we are suspended until 2:15.